Hi, my name is Josh Blackman. I'm the president of the Harlan Institute. I'm joined by my good friend, Julie Silverbrook, and we are hosting the Harlan Institute-ConSource virtual Supreme Court competition in the case of Abigail Fisher versus the University of Texas at Austin. And today we are joined by two excellent teams. The students from Valle High School, please introduce yourselves.
Hi, I'm Pamela. Hi, my name is Stephanie Garcia.
Thank you. And with the two teams from the respondents, please introduce yourselves.
Hi, my name is Harlan.
Hi, my name is Michael Miguel.
Very good. So, Julie, format?
So we're going to get started today by having petitioners begin. We'll argue for about 15 minutes. We'll ask questions throughout that time. Then respondents, you will also have 15 minutes. And both petitioner and respondent will have 5 minutes of rebuttal time to respond to things brought up during their argument. As Josh mentioned before we went live, the winners of this round will go on to our final round of the competition, which this year will be hosted in Philadelphia on April 13th as part of the National Constitution Center's Freedom Day celebration. So we wish both teams the very best of luck, and we will get started now. So petitioners, whenever you're ready.
And if respondents, if you just mute your microphones in the meantime, that way we don't have to be able to feedback. So if people want idea questions, mute your microphone. Thank you very much. Okay, petitioner, whenever you're ready to proceed.
Thank you. May it please the court, Your Honor, I, Pamela de la Cerda, and my partner Stephanie Garcia will represent the petitioner Abigail Fisher in this case today. I will speak on the 4 logic traps the respondents have created for themselves. I will be speaking for 8 minutes, and my partner will be speaking for 7 minutes, and we respectively request 5 minutes for the rebuttal. Your Honors, this case is about denial of a constitutional right and the denial of due process. Ms. Fisher respectfully asks this court to reverse the lower court's rulings for this court decision for the following 3 reasons. 1, the current status quo is creating and allowing inequalities to happen without a formal due process procedure in place for redress. 2nd, affirmative action was meant to be a temporary step to help, not a permanent entitlement program. 3rd, the United States federal government's affirmative action plans are against the 10th and the 14th Amendments. To my first point, the current status quo is creating and allowing inequalities to happen without a formal due process procedure in place for redress. The respondents are supporting the concept that it is okay for inequalities to happen without a formal due process procedure to be in place. Being rejected from the 16th top listed university in the nation without an acceptance rate of 39.7% is something a vast portion of prospective college students have experienced throughout the state, throughout the nation, and throughout the world. Abigail Fisher contends that she was not equally viewed in the admissions process merely because of her race. She is, however, incapable of proving so. The respondent claims there was no harm to Ms. Fisher because she cannot prove so. They are blaming the victim for the incident instead of taking responsibility for causing the incident themselves. This is a logical flaw of shifting the burdens. The process in which a UT Austin evaluates any submitted application is a holistic approach, regardless of any predominant factor. If the top 10% rule worked as claimed by the respondents, then the top 10% Texas law, which constituted for approximately 81% of admitted freshmen for the fall class of 2018, if the top 10% rule worked, then you would not need to recruit a diverse student body because this diverse student body would currently exist. By needing any other factor such as race, the respondents have lost the argument that the top 10% rule is working. This would mean that if you find for the respondents' logic here, then you must take out the top 10% rule as unconstitutional or ineffective because you do not need both. Can you create inequalities without a formal due process procedures in place? This is faulty logic on the respondent's side and must have been backed up by 2 overturned court cases from the past. First, Barron v. Mayor and City Council of Baltimore. The 5th Amendment restrains the power of general government, not as applicable to the states. The purpose was to stop abuse of power by the federal government. In them indicates that they should apply to the states. Imagine today thinking that the 14th Amendment would apply to a state or a state university. In Plessy v. Ferguson, in a 7-1 decision, the court held that as long as facilities were equal, their separation satisfied the 14th Amendment. Justice Harlan authored the lone dissent. Passionately, he clarified that the Constitution was colorblind, railing the majority for an opinion which he believed matched the Dred Scott in infamy. Imagine the idea that got some sort of fair shake by the office admissions because they were already treated equally poorly. Instead, the petitioner would like to offer a few words of justice John Roberts when he wrote in Parents Involved in Community Schools v. Seattle School District. The way to stop discrimination on the basis of race is to stop discrimination on the basis of race. This is a simple logic we would like to point out, an inescapable logic trap that the respondents have fallen into with their argumentation today. You cannot end discrimination by discriminating against others. Which leads me to my second point. Affirmative action was meant to be a temporary step to help, not a permanent entitlement program. The respondents are taking the position that affirmative action is a permanent position in their second argument of how the University of Texas at Austin meets standards set by preceding cases. The entire concept is flawed in several ways. First, Justice Sandra Day O'Connor wrote in Grutter v. Vollinger, while diversity on a campus is an important aim, this kind of affirmative action program should have a limit. She predicted that 25 years after the case, the use of racial preferences will no longer be necessary to further the interests approved today.
So, Counselor, are we at the point yet where we don't need racial preferences? I mean, Justice O'Connor said 25 years, and we can make fun of that number as much as we want, right? But it's the case that if the University of Texas does not use this form of affirmative action, they will not be able to achieve the diversity they think is necessary to have a critical mass in the classroom. Do you think that University of Texas could achieve that critical mass without using affirmative action?
Yes, diversity of opinion is more important than academic opportunity, not racial diversity. Affirmative action gives preferential treatment based exclusively on race, which is purely an external factor.
So, but the numbers bear out that before Texas was able to use the affirmative action program, their classrooms were not particularly diverse. How would you suggest that Texas could achieve a more diverse class without using this form of affirmative action?
Well, affirmative action is simply going on the base of race, so to achieve full diversity, it would not just have to be on an external factor. Would I say that question?
Okay, here we go. Continue.
Do you hear my answer? Okay. This logic is perfect for respondents today. Well, 13 years after Grutter, we now have our answer.
Hang tight.
Oh,
you were doing so good when the call dropped out. The call dropped. So we'll put time back in your clock. And I'm going to ask you the question that I asked you before, and then we can start over again. Is that okay with you?
Yeah, that's completely fine.
Okay,
So-
thank you.
Okay, so you still have about 2 minutes left on your side. You're about 6 minutes in. We'll give you another minute. So the question that I asked you is this: how should the University of Texas achieve its affirmative action policy? I'm sorry. How can the University of Texas achieve its desire to have a diverse classroom if they don't use some form of race-conscious admissions?
Well, there are several other ways to. What's happening? Well, there are several other ways to confront the situation. You can use a certain percentage of like I was saying, opinion is more important than the factor of race, which is simply an external factor. The University of Texas can admit people with different opinions rather than a different race color to achieve its diversity problem.
But Counselor, what mechanism can they use to ensure that they have a diverse student population? What kind of policies can they enact?
Well, instead of accepting those where their race is a predominant factor, they take those who are best fit for their college and their success, and exactly the best people that are best suited to their school.
Okay, so don't take race into account at all.
No, because race isn't what sets diversity, whether as mindset sets diversity. Only 26.9% of the whites actually graduate from colleges. From high schools. Is that
So, You're about 7 minutes in. Did you want to switch with your partner now, or how would you like to divide your time? Very good.
Thank you.
Thank you.
Thank you, Counselor. And ma'am, you have about 7 minutes to proceed. Go ahead.
May it please the Court, Your Honors. I, Stephanie Garcia, will represent the petitioner Abigail Fisher on the second point of error in this case today. Your Honors, this case is about the denial of constitutional rights. You cannot deny one person their rights and give something to another person without due process. First, the top 10% rule is discriminatory and against the 14th Amendment. Second, the unintended consequences of the use of race has resulted in more discrimination. We respectfully ask the courts to reverse the lower court's decision for these two reasons. To my first point, the top 10% rule is discriminatory and against the 14th Amendment. And second, the unintended consequences of the race has resulted in more discrimination. In the respondent's statements of facts, they state, the holistic approach of the University of Texas has caused significant controversy due to the fact that its admissions office considers race as part of the academic index / personal index achievement index. Score of applying students who do not meet the qualifications of automatic acceptance through the top 10%, Texas Law House Bill 588, which constituted for approximately 81% of admitted freshmen of the fall of the 2008 class. They claim that the top 10% rule works. The truth is much different. The top 10% rule is discriminatory and against the 14th Amendment. The entire top 10% rule is discriminatory and against the 14th Amendment itself. The top 10% rule is a provision that allows for all Texas high school students who finished in the top 10% of their graduating class to be guaranteed admissions at any public university in the state. In 1997, the Texas legislature approved House Bill 588, created by Representative Rangel D. Kingsville. The bill was a direct response to the 1996 Hopwood v. Texas decision on the Fifth Circuit Court of Appeals, which prohibited Texas universities from considering race in their admissions and financial aid decisions. To make sense of this, yes.
Question. Is top 10% a race-neutral plan? It doesn't take race into account?
I'm sorry, can you repeat your question? I didn't hear it.
Sorry. Isn't the top 10% plan a race-neutral plan? Does not take race into account. You're automatically admitted if you're in the top 10% of your high school.
Well, Your Honor, the top 10% rule, while it doesn't have race as a factor, it still affects schools of different races. So, in high schools, there was only a 26.9% rate of graduation from whites, and in high schools, the different high schools, some that are non-competitive get a higher advantage because they're non-competitive. So since it doesn't necessarily include race, it still includes race into the poorer schools or other schools or things like that. May I continue?
Proceed.
Thank you. To make sense of this and why it is discriminatory, cross-apply John Roberts, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. Representative Rangel wanted to promote ethnic diversity at Texas colleges and universities. The concept behind the fact was that the ethnic diversity was becoming larger and larger in high schools and all across the state of Texas, so if more high school students were to attend college, then more of those students would be diverse. Cross-apply, according to Steve Murdoch, director of Rice University's Hobby Center for the Study of Texas. Hispanics become the majority of total public schools students in Texas for the first time in the year 2010 to 2011. Since the trend
Counselor, I don't mean to interrupt. You made a time I'd like to the history of the 14th Amendment. And how should the history of the 14th Amendment affect how this case should turn out?
Well, Your Honor, the history of the 14th Amendment should affect the way this case turns out, because if you follow what the 14th Amendment says, which gives the equal rights to all people, then you would have to vote for the petitioner in this case. Because by allowing affirmative action and allowing race-conscious decisions in admissions policy or admissions actions, then you're going against the 14th Amendment and its whole list itself and in the history of it and the meaning of why it was created.
So, Counselor, maybe you can talk about some of the acts that came before the 14th Amendment and maybe how those impact our decision today.
Of course. I will get to it on later in my speech, if you don't mind me
continuing. Can you get to it now? We'd like to hear from it now, if it's okay with you.
Yeah, of course. So, later on, with the before the 14th Amendment, with the Freedmen's Bureau, they were taking land and property from whites and giving it to the freed slaves in order to help them. And in here, this was before the 14th Amendment and before due process and everything. But once the due process came around, they realized that they could no longer do this. They were not giving everyone their equal rights by taking from some and giving to others. They were also not giving them their due process by taking from some and giving to others. Within this, once the 14th Amendment did come around, then they realized that they had to follow it. They couldn't do what they were doing anymore because it was creating an unequal advantage to others rather than following the 14th Amendment and giving them the equal protection.
Counselor, if I can ask, doesn't the fact that the Freedmen's Bureau gave special treatment to the freedmen on the account of skin color, wouldn't that suggest that government today can give special treatment to minorities, again, on account of their skin color, to help them?
Well, Your Honor, this is why they had stopped the Freedmen's Bureau, because they realized that by giving them unequal, or by taking from some and giving to others, it was an unequal advantage, and especially doing this from the basis of race under the 14th Amendment, they realized that they couldn't do it.
But are we at the point today, I think I asked this to your friend a few minutes ago, where we no longer need this? I mean, are we at that stage where we have such an equal society that, schools don't need to use race conscious? I mean, is there still a place for race conscious measures in public schools?
Well, Your Honor, we're at the point where we don't need race conscious affirmative or race conscious decisions anymore. This society won't necessarily always be equal, but we can't prevent that. We can't force to change people's views. Again, there was only a 26.9% rate in high school graduations from white and a 53% rate graduation in high schools from Hispanics. So by saying that that we'll need this, that kind of means that we'll need it forever. And the whole point of affirmative action is to get rid of it eventually. And as you can see now, it's not helping at all. Especially right now, if you were to keep affirmative action, then you would have to let Abigail Fisher in because she is considered a minority in the state of Texas. But once again, we're trying to get rid of affirmative action as a whole because it's not
everyone's trying to get rid of it. In fact, the University of Texas is trying to defend it. They're trying to save it. Right?
Yeah,
I mean, not everyone agrees that this is something that's bad. Some people think it's good.
Yes, Your Honor, and I'm saying that on our side, we're trying to get rid of affirmative action as a whole. To make more clear, I'm sorry.
And let me ask, this court has accepted diversity as a compelling state interest, achieving diversity on college campuses. Do you acknowledge that that's a compelling government interest?
Well, Your Honor, and if you just give me just a second right here. There was also, I can't find it right now, but there was also a case, I can bring it up in my rebuttal, that actually says that it wasn't a compelling state interest and that they don't have the right to do it.
Okay, you have about a minute left, so do you want to go ahead and wrap up your argument?
Yes, please. Carefully consider the respondent's prayer. Fisher was denied on the basis of a valid rationale. In other words, it is okay to justify discrimination. It's okay to take from some and give to others. This prayer is why they should be voted down. If you think they are right, then you should vote for us because it wouldn't be fair to us. I do not think our opponents would agree to that, and by not doing so, they just agreed that we should win. For these reasons, we pray that Ms. Fisher respectfully ask the court to reverse the lower court's decision because, 1, the top 10% rule is discriminatory and against the 14th Amendment, and 2, the unintended consequences of the use of race has resulted in more discrimination. Thank you.
Thank you, Counselor.
Okay, Counselor, thank you so much. Okay, respondents, you are ready to go. And respondents, please unmute yourselves, and you may proceed whenever you're ready. You're still muted. There you go. There you go. Okay, we can hear you. All right, Counsel, you may proceed whenever you're ready.
Justices of this court, the holistic approach of the University of Texas at Austin has caused significant controversy due to the fact that its admissions office considers race as a part of the academic Index, Personal Achievement Index, AI, PAI, score of applying students who do not meet the qualifications of automatic acceptance through the top 10% Texas law, HB 588. UT's model, while established to diversify the student body, is being widely condemned by Americans, arguing that its methods violate the Equal Protection Clause of 1868. However, advocates of UT's methods argue that the consideration of race promotes diversity amongst the state university over a less preferable homogeneous student body and is vital in stimulating educational propositions. This controversial issue is certainly one in which my partner and I were obliged to scrutinize all aspects of. And having done so, we contend that the University of Texas at Austin should be permitted to use race as a decisive factor in their application process because it does not infringe on the rights of any U.S. citizen. Since her rejection in 2008, Abigail Fisher has attested to the fact that she was not equally viewed in the application process, thus evoking the question, does the Equal Protection Clause of the 14th Amendment permit the consideration of race in an undergraduate admissions decision? In answering this question, it is to the utmost vitality that the jury recognizes that Fisher's rejection was due to the fact that she did not meet the requirements of UT. Being rejected from the 16th listed top public university in the nation with an acceptance rate of 39.7% is something many prospective college students have experienced. Abigail Fisher contends that she was not equally viewed in the admissions process merely because of her race. She is, however, incapable of proving so. She lacks any verification on her behalf, and thus my partner and I maintain the position that she was equally viewed in all aspects. And being rejected was not because she was not a minority, rather because of her incompatibility as an ideal student of the University of Texas at Austin. The process in which UT Austin evaluates any submitted application is a holistic approach, regardless of race or any other predominant factor.
Counselor, can I ask you a question?
Economics, gender, rigor of taking class. Yes.
Sorry, can you hear? I would like to ask you a question. So here you're saying that the University of Texas at Austin takes a holistic approach, but earlier you said that it's appropriate for the University of Texas at Austin to use race as a decisive factor. So which is it?
Race is just one of many aspects of the holistic approach that the University of Austin takes. They consider the rigor of taking classes, they look at the students' essays, socioeconomics, they consider all of that in the holistic approach.
Thank you. Thank you for clarifying.
I'm sorry, it's not a decisive factor. Taking a look at Fisher's grade point average, according to Huffington Post, she had a 3.59 on a 4.0 scale. The standard GPA for UT is a 3.71, already putting Fisher at a disadvantage just through the university's mere consideration of a student's GPA. Moreover, her SAT score was an 1180 measured on the former 1600-point scale, which were good, but not enough to meet the standards of the highly selective flagship university. These two aspects of Fisher's admissions would have already placed her amongst the 25th percentile of applying students, meaning that in order for her to have been accepted, other factors in her application must have been noteworthy compared to competing applicants.
Counselor, if I can interrupt you for a second, do you see a logical stopping point of when we will no longer need to use affirmative action in public universities? Do you see a point where this will no longer be necessary?
Of course. That's the whole point of affirmative action, is to diversify a student body. So perhaps 25 years, as was said by Justice in Gruber versus Bollinger, perhaps in 25 years, affirmative action will no longer be necessary, but at this point, it is very much so necessary.
How will we know, Counselor? I mean, 25 years is a nice number to throw out there, but how will we know at what point this is no longer necessary? At what point this becomes impermissible?
Well, when we see racial assimilation in a university where we can go and say there is no majority race, that's when we know that the goal of affirmative action has been accomplished.
And then what percentage are we looking for? I mean, how are you matching up these percentages? I mean, what's with me no majority? I'm not sure what you mean.
Well, you, of course, can have a set quota, but there is critical mass is different from a set quota. That was established in Grutter versus Bollinger as well. So when you see that when you've established a critical mass at the university.
Right. No, I mean, and you very astutely you answered my next question. I was going to ask next. when do we hit the critical mass? How do we know when this occurs? That's my very next question, so you anticipated it, so I'll ask it now. How do we know when we hit the critical mass?
When we know that there's the critical mass has been reached is when the campus in its entirety is diversified, when we no longer see any race being put aside to perish. There's no community of African Americans that are just left behind. There's no community of Hispanics just left behind. When all communities in this nation are able to thrive the way that they should be.
And so, Council, let me ask you another question, right? To what extent should this court be concerned with whether, in fact, the universities are considering race as a holistic factor, or, to use your initial phrase, as a decisive factor, right? How do we actually know, like, how do we know what's going on behind the curtain, right?
Well, I know I believe it was Gratz versus Bollinger, the race accounted for 20 points in the admissions process, which was 1/5 of the total points that a student needed in order to gain admissions into the university. Race, it shouldn't gain any certain number of points, but when considering race in addition to socioeconomics, and we can also take a look at the students' essays and see what they have been through, the little opportunities they've had, and that should definitely give them an advantage to, let's say, an affluent student.
So, Council, you're right around the 7-minute mark. Would you like to switch with your partner, or however you want to proceed?
No, I'll continue. He'll do the rebuttal.
Okay, very good. All right, so, Council, let me ask you another question. You mentioned earlier in your remarks the top 10% plan. Do you think the top 10% plan is race neutral?
Yes, it is. The top 10% plan really just selects the top, well, doesn't select, but the top 10% of any high school is automatically admitted into the university. But that does not assist in any way through the use of race. I know it was meant to. The intentions of that plan were meant to help race, but it wasn't.
What was the intent? How was the top 10% plan intended to assist with racial integration? What was the plan, at least?
The plan was that students from a community of, let's say, Hispanics, a high school where Hispanics are the majority, they gain automatic admissions into the university.
So, I'm from Houston. I live in Texas, and Texas has a fairly segregated school districts. If you live in a nice city in Houston, you live in the bad city of Houston. I mean, this is no mystery to people. So why isn't it enough then to try and take the top 10% from some of the poor areas in Texas, from the more racially minority area, African American neighborhoods, Hispanic areas? Why is that not sufficient then to try to achieve this critical mass?
A perfect example of that would be Proposition 209, which completely eliminated the use of affirmative action in California educational institutes. After that, the enrollment of minorities dropped by 30%.
So what then lessons should perhaps we draw from Prop 209?
The use of, or the implementation of Proposition 209 really discouraged minority groups into applying to the university.
So, but one thing, Counselor, that I think you kind of ran away from my question before. I mean, you say we're not looking at quotas, but ultimately, when you talk about a critical mass, you're talking about a number. Whatever that number is, it's a number, and that's a quota. How do you reconcile then the court's decision, Bakke, saying no quotas, and your desire to have this critical mass, which, I mean, you can shake it down. It's gonna be a number. There's a number that will make you happy, right? How do we handle that?
There is no number. It's really just ensuring that all communities in this nation are able to flourish, that we don't leave any set community of Hispanics, any set community of African Americans, of American Indians to just perish, that all.
I mean, what's perishing? I mean, people are dying. I'm not sure. I'm not sure if they perish.
Like they wouldn't be given the opportunity to meet their fullest potential.
Okay, thank you. You have a question?
No. Continue on with your argument.
Huh?
You can continue.
Okay, thank you. Okay, so I'd like to go on to how the University of Texas at Austin meets standards set by preceding cases. Now, even if Fisher's qualifications had been better than average, the question still stands, is UT allowed to implement race as a part of the holistic approach? And the answer is yes. This is so because the University of Texas at Austin meets all standards set by preceding cases. In 1978, the special program ran by Davis Medical School was found to have operated as a racial quota because minority applicants in that program were rated only against one another rather than the entirety of applicants. 16 places in a class of 100 were specifically reserved for applicants coming from this special admissions program. This was the set quota that seized the court case, causing them to rule in favor of Bach. This case set the standards that all universities were meant to follow in order to avoid any claims of having violated the Equal Protection Clause of the 14th Amendment. In an 8-to-1 decision for Bach, justices of this court contended that any racial quota system supported by the government violated the Civil Rights Act of 1964. The University of Texas at Austin does not operate in this manner. Rather than reserving a number of spots or claiming some percentage of their students in which they aspire to have represent minority groups, UT has a narrowly tailored goal set to achieve diversity while maintaining the absence of a set quota. To presume that UT Austin maintained any system similar to that of Davis Medical School of the University of California would be considerably erroneous for numerous reasons. First of all, each applicant of UT is holistically evaluated. There are no special admissions programs specifically targeted for disadvantaged minority groups. There is no cutoff GPA for certain students and none for others. Each student's application is viewed in its entirety. There are no
I'm sorry, Counselor, I interrupt. I realize we're not dealing here with a program like the University of Michigan where being black was worth like 100 points in your SAT score. But can you describe a little more what it means to consider an application holistically? Like how much weight is given the fact that a person belongs to a specific racial group? How much weight is given to that?
Well, you can't specifically give a student a certain number of points for being this race or for having this income. Rather, you look at the application, you take into consideration the essays, what the student has been through, the ACT scores, SAT scores, you take a look at the GPA, you take a look at anything that has the potential to aid the student in attending the university, and you use that to their advantage into gaining admissions to the university. But there is no set number of points given to a student simply because they are black or white or Latino.
Okay, thank you. You only have about 2 minutes left, so why don't you go ahead and wrap up your argument?
Okay. In her case, the plaintiff contends that UT Austin does not have a narrowly tailored goal, something that has been demanded of all state universities that consider race in their admissions process, following the Regents of the University of California versus Bach court case. Her rationale behind this is that because the top 10% program allows for automatic admissions to UT for diverse students at the top of their high school's classes, there is no further need to use race as a determinative factor in the standard application process. However, the top 10% plan has not accomplished diversity as it was intended to, as we see that whites constitute for a profound amount of UT's population. In addition to this, the top 10% plan has been drastically altered. It now accepts only the top 7% of high school graduates, making it ever more strenuous and rigorous for students of any race to be admitted through this process. Yes, this plan did account for 81% of admitted freshmen in 2008. But since then, it has shrunk into account for 70% of the 2015 student body. And of these newly admitted freshmen, whites remain the predominant student body, forming 70% of admitted freshmen of 2015. And this is with the consideration of race as well as the top 10% plan. If the university relies solely on the top 10% plan to achieve the diverse, well-rounded student body any university should hope for, it will remain unaccomplished. To continue, UT Austin follows the regulations.
No, Counselor, you're out of time.
Oh, okay. Thank you.
Okay, thank you.
Thanks,
You will have 5 minutes for rebuttal after petitioners have an opportunity.
Thank you.
Your microphone, or I think can we do it for them?
No, I can't. There.
And you will have 5 minutes to respond whenever you're ready.
Thank you. May it please the court, I, Stephanie Garcia, will give the rebuttal on behalf of the petitioners today. We have pointed out the following flaws in the respondents' arguments. First, affirmative action leads to reverse discrimination. The respondents claim that 80% of the class of 2008 were top 10 students. They claim that Ms. Fisher did not deserve to get into UT. The respondent also claimed that it is race neutral. This is a reason to be voted down today. Here in their arguments actually prove our point. The top 10% rule was created in House Bill 588, and they reported 45.1% of the UT is white. All these facts prove our points. The top 10% rule has failed to produce more diversity, considering the fact that only 26.9% of the 2016 high school graduates in Texas are white. Instead of, yes.
Can I ask you a question? If you're conceding that the top 10% plan was not adequate in achieving diversity on campus, then isn't the University of Texas at Austin justified in taking additional means, additional steps to ensure that they do in fact have a diverse student body?
Well, Your Honor, by not at all, because whenever they went to make the top 10% into this 7%, it's actually doing the exact opposite of what they want it to do. Being that whenever there's only 26.9% of high school graduates that are white and 45.1% of students are white at UT. And here you can see that the affirmative action isn't working at all. There's kind of something going wrong in the steps of from high school to college, because if you're going from a small amount, which is 26.9 to 45.1%, then there's something wrong, and you can see that the top 10% rule isn't working, and by lowering it to the top 7% rule, it isn't working either. Second, it rewards wrong people and devalues a person's real accomplishments. They are claiming that Ms. Fisher was denied on admissions because she was not qualified to attend UT. However, she graduated from LSU in 4 years, or about 30% quicker than her peers that got into UT in 2008. Third, it pretends to solve a problem that no longer exists. Ms. Fisher was a minority. Ms. Fisher is a member of the class of students that have 26.9% of the student population across the state in 2016. That would make her a minority and allow her to get into the school at UT. Justice Sandra Day O'Connor wrote in Grutter v. Bollinger 2003, 25 years after this case, the use of racial preferences will no longer be necessary to further the interest approved today. Fourth, it makes minorities struggle more. House Bill 588 and Senate Bill 175 are not working. The respondent noted that 45.1% of the population is white, yet the petition has shown that only 26.9% of the students who graduate from Texas high schools are white. House Bill 588 and Senate Bill 175 were temporary fixes of the...
Counselor, I'd like to ask you a question, just a point of clarification. Okay, so if the top 10, you're saying the top 10% plan doesn't work to achieve diversity. The additional steps that the University of Texas at Austin took by evaluating a candidate holistically and taking into account their race, that's not achieving diversity. So is diversity just not a business that higher education should be involved with, or do they need to take some other steps to have a diverse campus?
Well, Your Honor, you can't necessarily have full diversity among a campus no matter what you do. No matter what actions you take, you can't fully have diversity. So by trying to achieve this goal, you're just taking away people's due process rights and their equal protection rights that they have.
So do you want us to reevaluate our past statements that diversity in higher education is in fact a compelling government interest? Are you saying it's not?
No, Your Honor, we're saying that it is. Okay.
It is a compelling, I'm sorry, it is a compelling interest?
Yes.
So if it's a compelling interest, then schools like the University of Texas at Austin can take different policies into account, right? And the question then becomes whether or not those policies are narrowly tailored to meet that compelling interest. Isn't that really where your argument should come down to?
Well, Your Honor, but as we've showed that it's not working at all. The top 10% rule isn't working to help diversity at all. Fifth, it perpetuates social division.
The respondents have claimed that in being rejected from the 16th listed top public university in the nation, the acceptance rate of 39.7% is something a vast portion of the prospective college students have experienced throughout the state. They have tried to justify discrimination by saying it was just statistics. No, we of the petitioners know that the discrimination is not just a statistic, it is a crime. 6, it denies due process rights. Cross-apply that you cannot take away rights from people without giving them due process. Representative J.G. Blaine explained that there is no longer any distinction between American citizens and that
sorry, you are out of time. I'm sorry.
Thank you.
Thank you very much.
Thank you, Counsel. All right, respondents, you have 5 minutes for rebuttal. And unmute your microphone, please. Hi there. Still can't hear you.
Nope. You want to press the microphone button.
There we go.
There you go.
All right, so you're 5 minutes. Whenever you're ready to proceed.
Okay. So I wanted to touch on a few points just so that we could clarify some of the issues in both arguments. First off, the top 10% plan. Both sides do agree that the top 10% plan isn't working for the university in establishing diversity on campus. It's not achieving the goal. And the top 10 plan is race neutral. It's not looking at whether you're Hispanic or you're a minority. It's looking at whether you're in the top 10% or in this year, top 7% of your class. So
if I can interrupt you, Counsel, you have a brief time, but as I discussed with your friend a few moments ago, the top 10% plan is premised on the fact that Texas high schools are de facto segregated, that there are certain areas where the top 10% are going to be all Hispanic. There's certain schools where the top 10% will be all African American. And there's certain schools like Sugarland High School, where Fisher went, where the top 10% is basically all white and Asian. So how do you square with that? The top 10% plan is race conscious, just in an indirect sort of way.
I do agree that it's race conscious. It was implemented to achieve diversity, but the plan in itself was made so that there would be no direct way to get certain races into the university. It's not looking at race when they're admitting these students. It's looking at your scores. And obviously it does have the intention of improving diversity on campus, but as we can see, as both sides agree, it hasn't been working. And so far, this plan has been the only one that the University of Texas at Austin has been able to implement in such a way that race is not being directly correlated to the final product. And because it's not working, I think it's very valid for the University of Texas at Austin to start looking at other ways that we could start integrating minorities onto campus, which is why we want to include race in our admissions process. I wanted to go over some other points as well. As far as the colorblind society, so we're at a point where definitely our society wants to eliminate looking at race as, oh, well, we don't want to look at race as something that either helps you in society or it diminishes your opportunity. We want everyone to be equal. We want to have an equal playing field. But we're at a point where we can't accomplish this yet by completely eliminating supporting processes such as affirmative action. If we really want to move into a colorblind society, then we need to make up for the centuries of inequality that we brought onto minorities. Specifically in California, minorities, Hispanics, even though they make up a large portion of California's population, they're still very behind in income status as well as higher education.
Counselor, if I can interrupt you for a minute,
yes.
Has that shake out for Asians? Should Asians also receive the same sort of preferential treatment in light of past discrimination against Asians?
Well, what we've seen here is that it's not really discussed, but there is a social stigma that comes with race. So when people think of Asians, the first thing that comes to their mind is, well, they're going to do well in their academics, and it's not something that we'd like to discuss, but it's there, it's present. So Asians, I'm being very general here. So when you have Asian minorities applying to these universities, although they have faced discrimination in the past, they're not in a position where they have fewer opportunities as opposed to other minorities such as Hispanics, African Americans, American Indians, who have shown that they are lagging in a bunch of other factors compared to Caucasians and Asians. And I'm looking more at socioeconomic factors as well as levels of education in their upbringing.
Very good. All right, Council, you have about a minute left. You want to wrap up?
Yeah. Okay. So I guess to sum up, what we're doing here is we want to establish the fact that the 14th Amendment, specifically the Equal Protection Clause, does allow the University of Texas to do this. So we have Grutter versus Bollinger that establishes that we can use race as a qualifying factor, as a state and governmental interest that would allow us to implement race into our programs. I know the plaintiffs did state that race was not considered a factor for parents involved versus Seattle School District, but that's specifically more for public high schools and not higher education, where diversity is very much needed and expected, because obviously you want to create a student that's very knowledgeable.
Sorry, Counselor. Unfortunately, you are out of time.
Okay.
But thank you very much for your responses.
Thank you.
So I'd like to thank both teams. You both did a wonderful job. You took a very difficult constitutional issue and you brought to it a lot of clarity, intelligence, wisdom, and foresight. I'm very proud of all of you. We'll be grading these very soon. We'll be in touch with you and your teachers in the next probably day or so, and hopefully we'll see maybe some of you in Philadelphia next month. Julie, anything like that?
Yeah, I just want to say congratulations also, and it just seems like the students are getting better every year, and commend you all for a job well done. You should be really proud of yourselves. I know you put a lot of time and effort into preparing for today's oral argument round. We congratulate you again, and again we'll be in touch in the next day or so with who will be moving on to the final round in Philadelphia. So thank you again.
Thank you very much. Have a wonderful day, and by the way, tomorrow is James Madison's birthday, so make sure you wish him a happy birthday.
Thank you. Bye.
Bye.